In this video, I'll explain settlement versus trial in Florida business litigation and give you a real strategy. And by the end of this video, you will learn exactly how to decide whether settling your business dispute or going to trial is a smarter move for your company. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've spent years in courtrooms and negotiating tables across the state, and I can tell you that the decision between settlement and trial is the single most strategic choice a business owner will face during litigation. Here's the truth most attorneys will not say out loud. Going to trial is not always the brave choice, and settling is not always the weak one. Sometimes the smartest play is to take the deal. Sometimes the smartest play is to fight. The difference comes down to strategy, not emotion. And that is exactly what we're going to break down today. Let me start with a number that shocks most people. Over 90% of Florida business litigation cases settle before trial. That is not a guess. That is the reality in Florida circuit courts and federal courts across the states. The vast majority of breach of contract claims, partnership disputes, fraud cases, and shareholder conflicts never see a jury. So why is that? It's not because everyone is afraid of trial. It's because the discovery process in Florida business lawsuits changes everything. Once both sides exchange documents, take depositions, and see the strength of the evidence, the picture becomes clear. The unknown disappears, and when the unknown disappears, the risk of trial becomes something you can actually calculate. Florida updated its civil procedure rules in 2025. Judges now move cases faster. Discovery starts sooner. Initial disclosures are now mandatory. That means both sides get to the evidence quicker than ever before. The old strategy, dragging out a case to wear down your opponent, is dying. Courts are not putting up with it anymore. So what does that mean for you? It means the pressure to make a settlement decision comes earlier in the case. You need a litigation strategy from day one, not day 300. Let me walk you through the situation where settlements make the most strategic sense. First, consider the cost. A business trial in Florida can easily cost six figures in attorney's fees alone. That does not include expert witnesses, court reporters, trial exhibits, or the time your team spends preparing instead of running the business. I have seen cases where the legal fees exceed the amount in dispute, and that is a loss no matter what the verdict says. Second, think about certainty. A settlement is an outcome you control. A jury verdict is not. I've watched strong cases lose a trial because a key witness did not perform well. I have watched weak cases win because the other side made a strategic error. Trial is unpredictable. Settlement removes that gamble. Third, there is confidentiality. Settlement agreements in Florida can include confidentiality provisions. A trial is public record. If your business dispute involves trade secrets, sensitive financial information, or internal conflicts you do not want competitors to see, settlements protect that. And here's the point business owners often overlook. Time is money. A Florida business lawsuit from filing to trial can take 12 to 18 months on a moderate timeline. Complex commercial litigation can stretch to 2 or 3 years. Every month that case is active, your attention is divided. And settlement lets you close the chapter and move forward. The key is this: settling is not giving in. Settling is choosing an outcome you can plan around. That is disciplined business judgment. Now, before I get into when you should absolutely take your case to trial, do me a quick favor. If you are getting value from this breakdown, hit that like button right now. It helps this video reach more business owners who need this information. And if you have not already, subscribe to this channel so you do not miss my next video on Florida business law strategy. Now, let me tell you when trial is the right move. Sometimes the other side will not negotiate in good faith. They make lowball offers, they stall, they refuse to acknowledge the strength of your position. When that happens, trial becomes your leverage. And sometimes you need to follow through on that leverage. Trial is also the right call when the dispute affects the future of your company. If someone is trying to steal your business, violate a non-compete, or push you out of a partnership, the stakes go beyond dollars. You are fighting for your livelihood. A court order or a jury verdict carries weight that a settlement agreement sometimes cannot match. There are also situations when you need to set a precedent. If you are dealing with a vendor, a franchisee, or a business partner who will test you again if you settle quietly, going to trial sends a message. It tells the market and your industry that you will protect your rights. And here's the strategic angle most people miss. Florida has a powerful tool called the proposal for settlement under Florida Statute 768.79. If you serve a formal proposal for settlement and the other side rejects it, and then the judgment at trial exceeds that proposal by 25% or more, you can recover your attorney's fees. That is a game changer. It shifts the financial risk onto the party who refused a reasonable offer. Smart litigators in Florida use this statute to put enormous pressure on the opposing side. It turns trial preparation into a settlement weapon. Here's where the real strategy lives. The best approach in Florida business litigation is to prepare every single case as if it is going to trial. That is not optional. That is how you create leverage at the negotiation table. When the other side knows you're ready for trial, the settlement numbers change. When they see organized evidence, strong witness preparation, and a clear damage calculation, they know you are not bluffing. Preparation is the foundation of every good settlement. I tell my clients to think about it this way. You do not settle from a position of weakness. You settle from a position of strength. And strength comes from preparation. In Florida, mediation is often required before trial. Many business cases settle during or shortly after mediation once both sides have been through discovery and understand what the evidence actually shows. Mediation is not a formality. It is a strategic opportunity. How you present your case at mediation can determine whether you ever see the inside of a courtroom. But here's where business owners go wrong. They treat settlement and trial as two separate tracks. They think you pick one path early and stick with it. That is a mistake. The smartest litigation strategy keeps both options alive throughout the entire case. You evaluate settlement at every stage, after the complaint is filed, after discovery reveals new facts, and after depositions, after summary judgment motions. The calculus can change at any point. Florida's 2025 procedural changes make this even more important. With stricter case management schedules and faster discovery timelines, the window for settlement discussions open and close quickly. You need an attorney who understands timing, not just the law. Let me leave you with something practical. If you are in a Florida business dispute right now, or if you think one is coming, here are the questions you should be asking your attorney. What is the realistic range of outcome at trial? Not the best case, not the worst case, the realistic range. If your attorney cannot give you that answer, they have not done enough work on the case. The next question is, what will it cost to get to trial versus what will it cost to settle now? You need both numbers side by side. Factor in your time, your team's time, and the distraction to your business operation. You also want to ask, what is the strength of our evidence? Contracts, emails, invoices, payment records, and witness credibility drive Florida business litigation. If your documentation is strong and your damages are clear, you have leverage. If the evidence is messy, settlement might be the wiser path. You also want to see, is there a proposal for settlement strategy that makes sense? Your attorney should be thinking about Florida Statute 768.79 from the early stages of the case. A well-timed proposal for settlement can fundamentally change the risk profile for the other side. And finally, ask this. What is the business goal here? Not the legal goal, the business goal. Are you trying to recover money, protect a relationship, send a message? The answer to that question should drive every decision in the case. The bottom line is this. Settlement and trial are both tools. Neither one is inherently better. The right choice depends on your facts, your evidence, your timeline, and your business priorities. The worst thing you can do is make that decision based on emotion. The best thing you can do is make based on strategy. Now, if you're a business owner in Florida facing litigation, get clear on your goals early. Build your case from day one and work with an attorney who knows how to use both settlement and trial as weapons in your favor. Now, if this video helped you think differently about your business dispute, hit that like button and subscribe to this channel. I put out videos every week breaking down Florida business law in a way that actually helps you protect your company. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.